I want to go back for a moment to licensing complaints. Licensing complaints are probably the one area where, from my perspective, the whole system is stacked against us. And if you look at it from a due process perspective, it's very strange. Our legal system for criminal actions is based upon what's called a due process or an adversarial system. And we're all very knowledgeable about that. All you have to do is watch TV one night a week for about an hour, okay? And you'll see in the US what the idea is about adversarial justice. It's a little bit of a parody, to be sure, but that's the idea, that you have representation and that you go before a neutral fact finder, a judge or a jury, who isn't involved in the case. That adversarial system is the hallmark of our criminal justice system, indeed our civil justice system. There's another system called the inquisitorial system. And the inquisitorial system was developed in Europe quite a while ago. And it involves having the person who gathers the information, that is the prosecutor and police, make the decision about whether we committed the crime. And in studies that have been done cross-culturally, internationally, about people's perception of fairness, it may come as no shock to you that the inquisitorial system is not seen as being particularly fair. It's seen as being very biased. And part of that is because the cognitive biases or the judgment heuristics that are anticipated that will happen if someone has to investigate a case. Right? So in our system, we've generally gone with an adversarial way of dealing with things. The idea is you have two sides that clash, and that what emerges from that, in some situations anyway, it's far from perfect, is going to be a better version of the truth than if we have just one side saying this is what happened. Particularly if you keep in mind that when folks make an assumption or have a hypothesis about what's happened, we have a very strong confirmatory bias. That is, we seek information to confirm the assumptions that we've made. Okay? And as I'm sure the psychic in the truck case, we did quite often and helped people with quite often. What does this have to do with licensing complaints? Well, the initial stages in any event, the initial stages of licensure process, if there's a complaint against me, are based on an inquisitorial model. In other words, I get a call from a, this is going to be the death of me today. I get a call from a investigator saying, Dr. Taube, I'm just calling about a minor issue that I want to talk with you about. By the way, you will get, occasionally people will get calls like that. There is no such thing as a minor issue. Okay? There is no such, we want to do an informal resolution. There's no such thing. They're lying. They may not think they're lying, but they are. Okay? There's no such thing. I have a minor issue that I wanted to talk with you about. And your client said that you engaged in an impermissible dual relationship and that you employed her as a consultant on a very large grant. And I'm thinking, client, consultant, very large grant? And I start to describe to this investigator what's happened, and he's listening and listening. Okay, sir, thank you very much, hangs up. And then a week later, I get a letter alleging that I've done something completely different with this client. What's going on here? That investigator gives information to the board. The board decides whether it's going to, actually, it's through the the Attorney General's office, decides whether they're going to bring charges against me. And if they bring charges against me, I get to go to an administrative law judge and have the administrative law judge do a hearing. Sounds good so far. Maybe even sounds like I'm not right about this idea of an inquisitorial process. Well, here's the rub. When I go in front of that administrative law judge and I've had my attorney make arguments and I testify and the judge says, Dr. Taube, you did not engage in any impermissible multiple relationship with this client, the board can overturn that. They can decide that they don't like the decision by the administrative law judge. Why? Because this is a license. This is not a right. What we have are licenses. Now, can I go to our legal system at that point and appeal the decision? Absolutely. But I've got to have a lot of money to do it. And it can cost $30,000, $40,000, $50,000 to go before an administrative law judge. And most of us don't have the kind of money lying around to then go to the Superior Court and then appeal it to the First Circuit Court of Appeals if that's necessary, and so on. So, in effect, we have an inquisitorial system. But what do we do? Well, what I should have done when I got that call from the investigator, the first thing I should have done was to say nothing. I should have exercised vigorously and with all of my passion my ability to remain quiet, which you probably all can tell at this point is not very well exercised. And one of the reasons that I need to remain silent, and that you need to remain silent if somebody is investigating you, is because they're not trying to help us get free and clear. They're trying to prove their hypothesis. There was a lovely series of studies that were done. Let me see if I can find it. Ah, there we go. Some researchers who, in this case, it was Saul Kassin and Rebecca Norwick, and they did a series of studies that involved trying to understand why people seem to sometimes confess to crimes that they didn't commit. And they did a couple of studies, a pair of studies. One study that I want to talk about in particular was a 2003 study by Kassin, Goldstein, and Savitsky. And what they did was they structured it to have investigators questioning people who engaged in either staged crimes or not. Okay, so they had randomly assigned, was this an actual crime that occurred? Somebody came in here and took the computer out of the room, or did somebody come in and put something down in the room? So there were people who were either innocent of a staged crime or guilty of a staged crime. And then they had interrogators who either were told that this person was guilty or told that the person was innocent. Okay, so they were given innocent assumptions or guilt assumptions. And then they had people, in this case I believe students, witnessing or observing these interactions between the investigators who had guilty or innocent expectations and the actual alleged perpetrators who were either innocent or guilty. Okay, so that so far makes sense? Kassin and his colleagues found that the interrogators with guilty expectations relative to those with innocent expectations asked more guilt presumptive questions, used more techniques, and tried harder to elicit a confession. All of that led observers to see the suspects as more defensive and guilty. So where there was guilty expectations, greater likelihood of the observers saying, you know, the suspect seemed more defensive and guilty. Particularly, interestingly enough, in fact, the most pressure-filled sessions, by all accounts, occurred when the guilty expectation interrogators were paired with innocent suspects. Couple these findings with the fact that innocent people at times confess to crimes they do not commit. Our results suggest the ironic conclusion that during the initial stages of a criminal investigation, read that, the initial stages of a licensing investigation, innocence may put innocent people at risk, particularly if you talk. Now, the concern that many of us have is that if we fail to talk and we go do number 2, which is get an attorney, then what will be considered guilty. And we see it in Hollywood all the time. They've lawyered up. They must be hiding something. I want to put your concerns about that to rest. They assume you're guilty. Don't worry about being seen as guilty. You're already assumed as guilty. In fact, if you go to board meetings and presentations at professional organizations, they will say, where there's smoke, there's fire. We assume that somebody who has had an accusation made against them is guilty. So the first step is be silent. Now, I'm not a member of the bar, so I'm not promoting the use of my services. And attorneys certainly have mixed reputations. But if the anecdotal evidence is at all accurate, there's a greater likelihood of having cases appropriately dismissed when you have an attorney present. Why? Because you're not involved trying to defend yourself, even if it seems like a bizarre accusation. In fact, sometimes those are the most difficult ones to even wrap our minds around. A client says that we, made them buy a house and then caused bankruptcy and da-da-da. Well, when you read some of these detailed stories where the findings of fact are actually that a therapist had clients move in with them, charge them rent, the more detailed, the more bizarre. Sometimes they're true. So don't expect simply because it seems bizarre to you that the board investigators will agree that it's bizarre. Rather, assume that you have to remain silent, okay? And it's not easy to do. Why? Because you folks are intelligent people, you're highly educated, and most of us still have just world assumptions. We think that the world is a fair and just place, at least in our small corner of it. We know that the world at large is terrible, but our friends and the people we know in our practices are reasonable. No.
Like a Kafka novel.
That's right. It's much more like a Kafka novel, on a good day. So it's important to kind of forsake our just world assumptions to at least a limited extent and make sure that we remain silent and we get an attorney. Now, in order to address a licensing complaint and have the resources to fight it appropriately, and notice I'm making an underlying assumption here. I realize it's rather radical. I'm making an assumption of innocence. I'm presuming innocence. Okay? We presume innocence when people are accused of heinous crimes. Well, my belief is that we should presume innocence for us as professionals when we've been accused of something before the board, okay? BBS or BOP. But in order to have resources, one of the things we can do for those of you who are in private practice is to be sure that you purchase the insurance rider if you're an LCSW or a psychologist that pays for essentially licensing defense. Why? Because most malpractice, unless you're an MFT, which I'll talk about in a moment, most malpractice will only give you up to $5,000, and you can burn without paying extra, and you'll burn through that in less than a week if there's actually a case that has to go to an administrative hearing. So it's not expensive. It's about $100 for $50,000 of coverage a year for psychologists. They're now offering in some organizations, some insurers are offering $75,000 of coverage because lawyers have got more expensive. Okay? It's well worth purchasing that. Now, I had a colleague of mine say, wait a minute, it's not worth it. If my chances are really low of having a licensing complaint and it actually going forward and so on, I shouldn't have to pay for this. You know, statistically, that's probably correct. But given that one only has to talk to about 10 people to find one who's had a licensing complaint, it may be worth doing it anyway. And I have no vested interest in insurance. I'm not invested in any insurance company. So this is not a personal profit issue. It's more of protecting oneself and being able to have the resources to go to the administrative courts and to go to the superior court if you've been mistreated in the process. If you're working in a government agency, for example, or you work for a large organization like Kaiser, almost always you'll hear, we pay for your malpractice insurance, but they will not say anything about licensing complaints and whether they'll defend us against licensing complaints. And the willingness of those organizations to do that is, well, I don't want to say spotty, but more, there's no way to know until it actually occurs. So when I was working for Alameda County, there was a member of my unit who had a complaint made against him, and we were constantly talking with county council because we were doing a lot of assessments that directly affected people's resources in the community, and we were in court all the time, and there was no question that they would defend a licensing complaint as well. But I've heard not only from folks in Kaiser but other counties that when they ask that question, the answer is no, we won't do that. So if you're not an LCSW or you can't get insurance through NASW's insurance affiliate, then there are a couple of things you can do. One of them is first find out through one's supervisor and, if you're in Kaiser, for example, regional counsel, whether there's a policy about defending you. And then secondly, if there isn't, or if you're in a nonprofit, for example, and they say, what? Then the other thing one can do if you're in a large enough organization is make it an issue of a benefit for people if you're in a collective bargaining circumstance. Say, and it's not very expensive for organizations to do, and it actually makes sense for them to cover those kinds of situations. It's less expensive for them to do that than it is for them to have to replace people, that sort of thing. Difference between licensing complaint and malpractice. Malpractice is when somebody sues me for falling below the standard of care in civil court and they're trying to get money from my insurance company. That's a malpractice case. Almost always. They may be asking for a cease and desist, but most of the time they want a dollar amount. There's some damage. So I'm in superior court, and it's not related at all to the licensing process. A licensing complaint is when somebody complains, and are you a psychologist or MFT? Somebody complains to the BBS and says, you weren't available when they were feeling suicidal and they therefore hurt themselves, and you were, as a result, you fell below the rules that say you have to be available, okay? That licensing complaint is directed at not giving money to the person who's making the complaint, but determining whether you should be practicing any longer. And so they'll remove your license if they find it true, or if they say, well, it's true, but it wasn't that serious, you might be put on probation on it. So it's two different systems. Conceivably, they could be happening concurrently. They often don't, but conceivably I could be sued in malpractice for doing something, have a licensing complaint, and also be sustaining a professional ethics complaint to my professional organization. There are a few behaviors, including, interestingly enough, it's a misdemeanor to have sex with your patient. You could be put in jail for that as well. And if you do it more than once, it's what's called a fence sitter. The prosecutor can decide to go after us as a felony, which means you go to San Quentin. Okay? So there are some activities that are regulated under our licensing laws that are also criminal in nature. But it's fairly unusual for professionals to be criminally arrested and end up in jail. It does happen on occasion, but to end up in jail as a result of something related specifically to licensure. On the other hand, if I'm New Year's Eve and driving down the road and I've had 3 or 4 glasses of champagne and I get pulled over for driving while intoxicated, I could be jailed, all of the ramifications of losing my driver's license and so on, but I also could put in jeopardy my professional license because that behavior, very arguably, is substantially related to my practice as a mental health professional.